and that is written by the petitioner in this case, asking for this relief, immediate suspension, and then permanent removal, never being able to hold another judicial office in the state of Oklahoma, is the Chief Justice of the Supreme Court of Oklahoma, John Kane. That's as bad as it gets if you're a judge. This is wild. This is horrible. I cannot believe that this is happening for any judge in our country. What's up, everybody? And welcome in to another video here. And this one is crazy. This one's legitimately crazy. A lot of you sent me this, and I couldn't believe it when I saw it. It's a completely random case. We're not going to get into what the lawyers argued during trial, whether we think the jury's going to think this or that, whether a witness was believable. Instead, we are going to focus on some judicial conduct. And we've talked about judges. We try to be as respectful and fair to every judge as we possibly can be. They're in a respected position. They deserve respect. They've earned it for the most part. But if we see issues, we will talk about them. This isn't the first judge that we've felt there's been some issues during trial, but this one definitely raises the bar in unbelievable, inappropriate, horrible actions taken. And it's like sometimes we'll think things will immediately pop into our heads and we know we shouldn't say that, it would be inappropriate. The fact that we thought it is what it is, some of that just happened naturally, and we can't control that. But what we do after we get that thought, we absolutely can control and we are responsible for. And in this case, over and over again, to the tune of over 500 text messages that this judge sent during a trial that she was the presiding judge over, have been released, discussed. The Supreme Court of the state of Oklahoma has made a recommendation of what they think should happen to this judge, and that's what we're going to talk about on this video today. What did the judge do? Is it inappropriate? What should the punishment be? And what can we learn from this situation? Because it is absolutely unbelievable. So if you guys enjoy videos like this, hit the like button, subscribe to our page, and let me know. Send me stuff that is shocking and wild, and you can't believe that actually happens in our judicial system. And here's another thing that I'll say about this one is, this is one that probably has happened before, at least with this judge and maybe with other judges, but just hasn't been caught. So what we can gather from this is hopefully at least something to deter judges from doing this in the future. For the most part, judges are respected, but also respectful. So it's probably not as a huge issue, but wherever it does arise, do we have to nip this in the bud? Because not only is it horrible, not only should it make people not trust our legal system if this does happen to them, but it also, according to the Supreme Court of that state, potentially affected the outcome of this trial, which was a very, very serious trial. So let's jump into this article, and I'm going to start just with a picture. And as you can see, there's a lot of cameras in this courtroom, and this is not necessarily a live stream trial, but a lot of courtrooms have CCTV camera for reasons like this, but also just so that, young state attorneys can watch or other judges can watch what's happening in their trials. Supervising attorneys can watch lower level attorneys trying cases if they need to critique them, things like that. But in this case, the judge did this knowing there are these cameras everywhere. But when she actually thought about it and reflected on what she had done, instead of owning up to it, apologizing, trying to work through it, whatever that may be or look like, she ordered that a privacy screen, so a big black box, basically cover her entire desk so nobody could actually see her throughout this trial. But then the board who determines things like this voted to remove that screen. And then this trial, I think, happened a couple months ago. And then all of her text messages were ordered and sent up because complaints were made about what she did throughout this trial. And let's take a look at some of what that is. An Oklahoma Supreme Court justice wants a judge removed after an investigation found 500 text messages sent to her bailiff during her first M trial and possibly her last. The alleged text messages appear to be making fun of prosecutors, witnesses, and jurors. So nobody's safe with this judge. Prosecutors, witnesses, jurors. Lawyers, witnesses, jurors. As first reported to the Oklahoman, Supreme Court Chief Justice John Kane said he wants Lincoln County Judge Tracy Soderstrom taken off the bench. And you can see the full petition here. So what are some of the violations and why they think she should be removed from office? First, gross neglect of duty. Second, gross partiality in office. Third, oppression in office. And fourth, other grounds specified by the legislature. So here we go. Let's get to what she did. While presiding over a murder trial beginning on June 7, 2023, the respondent exchanged over 500 text messages with her bailiff, Angela Miller, in which they mocked the physical appearance of attorneys, jurors, and witnesses and used offensive language to deride the state attorneys. The respondent and her bailiff called murder trial witnesses liars, admired the looks of police officers who were testifying, disparaged the local defense bar, expressed bias in favor of the defendant, and displayed gross partiality against the state. Very unusual, but even when it happens, you're going to hear me and everybody else hopefully say that's totally inappropriate. Whether you're against the state, for the state, against the defense, for the defense, totally improper, cannot happen, has to be punished. Judges cannot do this. They texted back and forth continuously throughout the trial. The judge was scrolling Facebook, accessing various phone applications, and texting for extended periods of time. The bailiff, sitting in a witness box or at a small desk near the respondent, sent and received text messages throughout, so it's people within the courtroom. Excessive phone use during the trial, even if it wasn't just text messages. Pattern of conduct is gross neglect of duty. So even if she wasn't texting anything inappropriate, the fact that she's on her phone the whole time, jurors aren't supposed to be on their phones, witnesses can't be on their phones, people in the courtroom can't be on their phones, yet she was on her phone basically the whole time. So even if there was nothing inappropriate, and let's get to some of the texts here. While the district attorney was addressing jurors during voir dire, respondent texted that he was sweating through his coat, to which the bailiff responded, "Yeah, it's gross. He's gross and a horrible speaker," talking about the lawyers arguing in front of them. Regarding the ADA, the respondent commented, "They are going to hate him," referring to the jury as they. The bailiff responded, "Absolutely, he's an arrogant a-hole." The bailiff then made a crass and demeaning reference to the prosecuting attorney's genitals, to which the respondent replied with a ha-ha icon. I mean, this is absolutely unbelievable that a judge and a bailiff are doing this. Think about just feeling like you're untouchable and able to do these things. I don't understand the mindset that people get in when they start acting like this and talking about other people in the profession, in their courtroom, in a profession of ethics. This judge has probably reprimanded people from being disrespectful or inappropriate in her courtroom before. And I mean, just the hypocrisy is wild. The DA made reference to a BLT sandwich, and the bailiff remarked that the defense attorney threw his BLT analogy back at him. The respondent replied trash with various emojis to reference the trash and the BLT. At no time during these exchanges did the respondent admonish the bailiff not to discuss the attorneys appearing before the court in such an inappropriate way. Instead, the respondent joined in on the commentary by again referencing the DA's appearance and stating, "Why does he have baby hands? They are so weird looking." The bailiff replied, "I was told they were tiny. LOL." Again, we've talked about it before, how low-hanging fruit it is to make fun of somebody's appearance, how it's inappropriate. Just generally, we don't even do it on YouTube, right? Where we're not, acting as lawyers and judges here on YouTube. We're just discussing cases, discussing witnesses, whether or not they're believable is totally different than talking about people's genitals and their hands and how they're disgusting and gross. Like that stuff is just, there's no place for that anywhere, in my opinion, about what people look like and can't control about themselves. Even worse to do it as a presiding judge in an official position of authority. Conversely, when the defense attorney addressed the judge during voir dire, the respondent remarked, "She's awesome." The bailiff responded, "Yep, and she's so smart." So again, starting to show partiality toward the defense attorney and against the state. The judge sought to swear the jurors in. The state objected, requesting a ruling on Dr. Brown's ability to testify, noting that the state would lose its right to appeal and double jeopardy would attach. Once the jurors were sworn in, the ADA said he thought all parties agreed the matters would be taken up before the jury was sworn in. Respondent overruled the state's objection and swore in the jury. So now this stuff, making decisions against the state, unless there's some text message that says, I did this because I don't like the defense attorney, a judge is ruling to me, could still be potentially protected, but I think this entire trial is colored by this judge's actions, to be honest. During opening statement, the respondent continued to praise the defense attorney by texting her bailiff, "Can I clap for her?" Listen, and again, do I think that judges think this sometimes while they're listening to cases? Absolutely. Do I think they think one attorney does a lot better than another attorney in some cases? Absolutely. Do I think that they start to think maybe I believe this side or the other? Absolutely. But they cannot allow it to affect their decision making. They can't allow anybody in the courtroom to know that. The jury can't feel the judge is leaning one way or another. The judge should not affect the process no matter what the judge thinks or believes personally. Does that mean they will never have a thought? Does that mean they will never think a jury got it right or wrong? Absolutely not. They're human. They can have those thoughts, beliefs. All of that is totally appropriate. We don't ask judges to be robots, but they cannot show partiality. They cannot affect the outcome of a trial ever, unless, of course, they're the ones making the determination. Then referencing the DA, the respondent said they are not used to going up against competent attorneys, implicitly dismissing the capabilities of the state attorneys and the defense bar. So basically she's saying the public defenders all suck. They're not used to an attorney like this. I don't even know if it was a public defender, but that's basically what that implies there. When the DA began to question witnesses, the bailiff texted, "He's horrible," to which the judge responded, "True." Every time you see respondent, that's the judge texting. Bailiff said, "Sucks." While a video was played to a witness on the stand, respondent remarked, the bailiff, "This is boring." While another interview was played, the bailiff mistakenly thought it was a video the state had previously lost. The respondent texted, "They didn't lose this one, but they should have." And the bailiff replied, "It doesn't help the state at all," to which the respondent affirmed by texting, "Nope." So now discussing rulings on evidence, what she should have done, but she let it in. It's not going to help him anyways. I mean, this person has no business being a lawyer, let alone a judge. Later, the respondent texted, "The state just couldn't accept that a mom could hurt their baby, so they went after the next available person, evidencing her opinion that of the defendant's innocence." And again, if the judge starts to believe the defendant's innocent, disregarding evidence or whatever it may be, they can't start making calls that go against the rules of evidence. If there's probable cause and that call has been made, and now the case is before the jury, it's up to the jury. The judge can't take it out of their hands by slanting the case in favor of the defense and making evidentiary decisions in favor of the defense, or vice versa. If they believe the defendant's guilty, they can't start making evidentiary decisions that slanted in favor of the state. The respondent later texted, "This is dumb," during the state's direct examination. And the bailiff replied, "I just hope the jury doesn't buy his." The respondent commented, "He looks constipated." Is that the OS look? And again, imagine for a second that the judge was letting the jury know of her feelings. Maybe any facial expressions were happening. And this is some of the stuff that's discussed in the Murdaugh case. Was the clerk of court, who it's okay if she has her own ideas and thoughts in her head, but if she starts sharing that with the jury in the way the judge was sharing this with the bailiff, you can see how that would be a problem. Not to say it rose to this level, but just if there was a comparison here. The judge basically spent the majority of the co-defendant's testimony on her phone texting comments like, "Can I please scream liar, liar?" So there's a husband and wife. Wife pled and was spending 25 years in prison. Husband was on the stand, is again for hurting their baby or their child. And obviously the judge thinks the mom is guilty and the dad is innocent. And so she wants to scream liar, liar while the mom is on the stand. When a police officer took the stand, the judge texted, "He's pretty. I could look at him all day." To which the bailiff responded, "Same." Totally inappropriate. Maybe people are more used to men making comments like this, but it's just as inappropriate when a judge who's in the power position in a courtroom says that about a law enforcement officer called to testify about a case. The respondent and bailiff also discuss whether one of the jurors is wearing a wig, with the respondent texting, "That's a wig. Look at that hairline." And later she texted, "Definitely wearing a wig," to which the bailiff responded, "OMG, LOL." They wondered if another witness had teeth, and the respondent texted, "No, star witness right there." Again, just making fun of people's appearances is so gross. I always say you should basically act like every one of your text messages is going to be read aloud in a court document. And I think we'd all be a little nicer and better and more appropriate in our texts. Because again, the initial thought that pops in your head is not as condemnable about what you do with it. Is she blinking uncontrollably? The respondent offered her opinion to the bailiff that DNA excluded Marzell on the bed. No way they get guilty on him. During the trial, a respondent approached Sergeant Kelly Coleman and some other officers and stated that the co-defendant was not believable. She did not think the defendant would be found guilty and he would only be sentenced to credit for time served. She granted the defendant's request for an additional jury instruction for manslaughter 2, which carries a sentence of 2 to 4 years. She took the state's request for murder 2 instruction, which is an 85% crime with a punishment of 10 years to life imprisonment under advisement. Later, she denied that and didn't even allow him to ask the jury for murder 2. The respondent notified, so the judge notified the bailiff, we are giving an alternative instruction of second degree M. The bailiff responded, but no, just enabling child abuse. He didn't hurt that kid to that level. The respondent answered, no, man 2 fits. Can't just do enabling because there is a death. Bailiff responded, so basically mom taking the plea deal screwed him over. Respondent said, no, man 2 is 2 to 4 years. Enabling is 255 to life. I'd rather give the man 2 instruction. The bailiff responded, he's already served that. The respondent replied, yep. So there you go. So I mentioned before, judicial decisions only become problematic if we actually literally have like a text message or email where the judge actually says she did it so he can get out on time served. And guess what? We have that in this case. It's the first time I'm reading this petition with you. I've only read quotes of the text messages. So can you believe that? Sometimes we'll argue a judge may have done this for this reason or that, but it's almost impossible to prove. Well, guess how you prove it? With text messages or emails where the judge gives their exact reasoning, which is horribly inappropriate as to why they do something. Later that day, the judge denied the state's request for murder 2, but allowed it for manslaughter. So here we go. After the judge became aware that a 51-minute video snippet of the trial had been publicized showing the judge's excessive amount of time on her phone, the camera was moved forward at the respondent's request to exclude her desk from view. The move left a gaping hole in the ceiling. The camera was later moved back to its original position, but a black box was inserted to block out the bottom half of the viewing area so the judge's desk could not be seen. The county commissioners then voted to remove any obstructions from the camera's view, reasoning that the respondent was not the only judge using that courtroom and that other judges like Judge Mueller did not have a problem with the original placement. When on vacation, Judge Mueller received a phone call from a courthouse employee who told her the respondent, the judge in this case, said she either can't be trusted and or better watch her back in light of the county commissioner's decision. So basically threatening other judges that if she can't have that black box so people can't see what she's really doing, there might be a problem. And the judge stated in front of the county commissioners that she was texting about things that probably could have waited for later, instead of recognizing these types of communications should never be made at all. The judge also attempted to mislead the counsel regarding the timing of her text messages by stating that most of the time she was texting between when a witness would come on or off or when there was a pause, which was just basically a lie. That's the point of the cameras. What do they say? Men lie, women lie, but the cameras don't lie. When asked if she recognized it was inappropriate at the time, she explained it was like, oh, that's funny, move on. Doesn't sound like that while we're reading them, does it? Let me know in the comments how inappropriate you think this is. I mean, this is crazy stuff to me. All right. So the judge's in-person testimony. She came before the council on judicial complaints on July 24, 2023. Within the first 6 minutes of her testimony, respondent used the F word 3 times. In all 3 instances, respondent was recounting a factual event or her strong feelings when she learned the council on judicial complaints had subpoenaed her personal cell phone. During her testimony on the council, she exhibited a pattern of offering misleading or false statements or arguments. I mean, when somebody's caught and they start lying and dropping F-bombs, listen, there's nothing wrong with cursing generally. It can be very inappropriate in certain situations. I mean, some people have a problem with it. And I think it's more the heart of the issue of why you're saying what you're saying. Because I think people can use other words that just have just as negative of a meaning or fighting words that is not, a typical curse word. But I think using it in certain situations does make you look bad, as evidence here that it made it in this petition here that she was just dropping F-bombs left and right and misleading the council, which I think has a very negative inclination here or inference to anybody reading this on how the council felt about the language she was using. The petitioner alleges that the circumstances giving rise to the foregoing facts against respondent are in grave danger of continuing. There's no evidence the respondent will voluntarily cease and desist in the performance of those matters which gave rise to the filing for this petition. There is an existing emergency justifying the trial division of the court on the judiciary of the state of Oklahoma and temporarily suspending the respondent from office pending the determination of the proceedings in this action. Great and irreparable harm and injury will occur if respondent is allowed to continue in the capacity of a district judge of the 23rd Judicial District of the state of Oklahoma. She needs to be booted from the bench immediately. She has a lack of remorse. She continues to try to mislead or lie about what happened. She's angry that they got her text messages, which prove what she's saying is not true. What do you think about this immediate suspension? Do you agree with it or disagree with it? Let me know in the comments. I obviously agree with it. So what is the relief requested here by the petitioner? Petitioner alleges that the above enumerated acts by respondent warrant discipline by the court on the judiciary as authorized by the statutes and the Constitution of the state of Oklahoma. Petitioner respectfully requests that this court on the judiciary enter an order removing Judge Tracy Soderstrom from office as district judge in and for Lincoln and Pottawatomie counties, Oklahoma, and the 23rd Judicial District of the state of Oklahoma with disqualification to hold any office in the state of Oklahoma. And that is written by the petitioner in this case, asking for this relief, immediate suspension, and then permanent removal, never being able to hold another position or judicial office in the state of Oklahoma is the Chief Justice of the Supreme Court of Oklahoma, John Kane. That's as bad as it gets if you're a judge. This is wild. This is horrible. I cannot believe that this is happening for any judge in our country. But I want to know what you think. Are you shocked? Are you appalled? Let me know in the comments. Let me know what you think an appropriate punishment is. Do you think she should be disbarred and not even be able to practice law? I think this should be submitted to the ethics committee, to the state bar, and I think it should potentially go further. I mean, everybody makes mistakes, so maybe if she does go into some kind of program and retake the bar again and take the ethics class again, then I believe in redemption, obviously, and her to be able to come back and do that. But right now, it doesn't seem like she has that kind of an attitude. And if not, that's a dangerous person to have the power to be a judge or even a lawyer. We've seen how lawyers can screw people. We have seen how people trust lawyers. And with great power comes great responsibility, and she has not handled that appropriately, in my opinion. But I want to know what you guys think. Thanks for sending me this because this is wild. This blew my mind. I have not seen anything like this proven and in black and white, literally, for these text messages. And I think the bailiff should have some repercussions as well. But all right, that's all we got for today. Thanks for joining me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us, lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.